Intellectual property, such as patents, copyrights, trademarks, and trade secrets, can be a real value enhancer for a startup. IP can provide a competitive advantage through the ability to exclude others from providing a similar product or service. IP can help a startup to differentiate its product from legacy solutions and competition. IP can demonstrate a startup's ability to innovate, making it an attractive vehicle for investment or acquisition. And IP can be commercially exploited through licensing programs and royalty streams. Establishing clean ownership of its IP is a threshold issue to forming a new startup. Every startup needs to carefully consider prior employers' rights and founders' obligations with respect to the IP of the proposed startup. Among other bodies of law, contractual obligations and state trade secret laws need to be analyzed to determine whether the startup even has the ability to pursue its proposed business without infringing upon or misappropriating the rights of the founder's prior employers. In addition, most startups have begun to develop protectable IP even before incorporating, so aggregating the IP into the corporate vehicle and obtaining valid forward-looking automatic assignments of IP to the startup are key to the startup and not the individual founders or employees owning the IP. Investor due diligence into a startup's foundational IP and IP protection practices can make or break an investment. From patent landscape surveys, patent prosecution file reviews, diligence into founder and employee invention assignments, and company representations and warranties in investment documents, investors will seek the comfort of knowing that the value they have ascribed to the startup is supported by the value of its IP. Many a startup financing has been killed because of undisciplined departures from prior employers and fear that prior employers may have a claim against the startup. Many a startup financing has also been killed by fractures among the founder group, coupled with some of the founders departing without having assigned their IP into the startup, usually as a result of a dispute over equity allocations. Finally, many a startup financing has been killed when investors conclude that a much larger, better staffed, and better funded tech company can build the same technology without impediment. Acquirers will conduct in-depth due diligence into a startup's IP to make sure they're getting what they bargained for, they are not assuming unwelcome liability for IP infringement, the target's IP supports the valuation ascribed to the target and the purchase price of the acquisition, and that the target will not suffer a loss of IP rights upon a change of control. With meaningful M&A remedies of indemnification and the escrow of a portion of the purchase price, hard-nosed negotiation over IP representations and warranties will allocate various risks between the acquirer and the target. Special purpose indemnities and escrows, and separate survival periods and limitations on liability will all be used to negotiate the true price of the acquisition with respect to the target's IP.